My name is Harold Meyerson. I am distinguished from all the other panelists in that I am not, now nor have I ever been an attorney. I am a columnist for the Washington Post and an editor-at-large of the American Prospect magazine, and I am here because I am one of the last 3 American journalists who writes about labor. And let me just remind you before we get started, please turn off your cell phones. I've already turned off mine. And this panel, No Worker Left Behind, is sponsored by the Service Employees International Union. If you want to thank them personally, go up Connecticut, go around DuPont Circle, make a right in Massachusetts, and there they are. I will just make a couple remarks, briefly introduce our panelists, since their fuller resumes, all of them stellar, are in your packet. It's clearly a vexatious time for American workers. The economy makes that self-evident. For workers who are unrepresented by unions, many here believe that that makes it even a more vexatious time. That would include slightly more than 92% of all private sector workers in the United States. And in their efforts to join unions, they have encountered numerous obstacles. According to Kate Bronfenbrenner, looking at 1,000 organizing campaigns for 5 years in the middle of this decade, in 34% of those campaigns, some of the worker activists have been fired, which of course is nominally a violation of the National Labor Relations Act, but the penalties are such that in many ways for employers it is a rational, if not per se legal, move. Similarly, there's been a great deal of work by folks at MIT on how many times workers get recognition yet fail to get a first contract. Another problem. These were problems that many had thought would be remedied with the election of Barack Obama and a heavily, but not quite heavily enough, Democratic Congress by the passage of the Employee Free Choice Act, which is one of the major things here in Washington over the last year and a half that did not happen. And in some sense, part of the focus of this panel, therefore, is what now? What organizing tools are available to workers and different groups of workers? Are there things that can be done on the state and local level? What about the particular plight of immigrant workers? I think one of the other expectations raised by President Obama's election was that there might be immigration reform, a path to legalization for workers. The political space for that, I think someone was calculating, would be created by the perhaps stricter enforcement of the existing laws. Instead, what we have gotten is stricter enforcement and far more deportations than we had under the previous administration of the existing laws, but the political space to have been created by that still is stubbornly not there. And finally, we meet at an interesting moment in just labor news generally, looking at what's going on in China. And here, China seems to be a place where there are strikes but no unions, just as we are a place where there are unions but no strikes. The interesting thing about both countries, since neither country is particularly union-friendly, at least as we understand in the Chinese context, that what they have officially is not, as we would recognize it, a real union, is that these are both countries in which the wage share of GDP has dropped over the last quarter century. Of course, in China, GDP has been rising so rapidly that doesn't mean an absolute drop, but the power of workers in both countries are very contested issues. And then finally, we meet here, of course, a couple days after the Supreme Court by a 5-4 vote said that the National Labor Relations Board really can't chug along with only 2 members. And so just to add to the complexity and to give some sense of the bitter divisiveness that affects labor relations in the United States, we have that decision here on, very thoughtfully, on the eve of this very panel. We have 4 distinguished panelists today. Each of them will speak for 5 to 7 minutes, then I will engage them in some cross discussion, and then we will have questions and from the other folks in the audience here. And as I said, I'll be very brief here. Ben Sachs is an assistant professor of law at Harvard Law, having come over there from Yale Law, where he was awarded the Yale Law Teaching Award in 2007. And then moving to his list, Ana Avendano is in a newly created position. Rich Trumka has been very, I think, very creative and very shrewd in his reshaping of the AFL-CIO staff. She is now the assistant to President Trumka, Director of Immigration and Community Action at the AFL-CIO, focusing on issues of concern to immigrant workers, and was working in the counsel's office there before she did that. Maggie McCann, Associate General Counsel for AFSCME, joins us today, and has worked also for the Department of Labor, NLRB. It says here she actually did some organizing at some point for SEIU, which has got to be the hardest job she's ever had, based on my understanding of what SEIU organizers usually are compelled to do. It's not the kind of position where working conditions, anyway, union staff positions are tricky. And finally, Willis Goldsmith here today, largely, I think, to present a contrasting viewpoint, though I found that he and Ben Sachs were equally disappointed that the Celtics lost. Joins us today. He is the partner in charge of the Jones Day Law Firm's New York office. I love that title, partner in charge. I mean, you can think of a number of corporations these days that would not like to have a title of anyone being in charge. And he is certainly one of the most distinguished members of the employment side, employment bar, usually on management side. So with that, let's begin with Ben.
Great. So federal labor law is supposed to do two basic things. The first is the law is supposed to ensure that workers have a choice on the union question, that workers can decide, free of coercive interference, whether they want to bargain individually or collectively with their employers. The second thing that labor law is supposed to do is that it's supposed to ensure that when workers choose a union, that employers and unions will in fact negotiate collective agreements. Now, these are profoundly important guarantees. Unions are, of course, not perfect institutions, but in many settings, unionization is the only genuine mechanism through which employees can participate in the shaping of their own work lives. Unions have also proven across time and across geography to be an effective force, in many ways the most effective force for wage and income equalization. Unions have produced desirable shifts in the way that compensation packages are structured, giving workers health insurance and pension benefits when those things aren't universally available. Unionization also improves the chances that other workplace rights will be enforced, minimum wage, safety and health, and the like. And finally, a vibrant union movement seems awfully important to the health of a political democracy. The problem is, as Harold already mentioned, federal labor law doesn't work in the United States. It doesn't fulfill its central statutory mission of giving workers a choice on the union question. So a big part of the problem is that the NLRA, the National Labor Relations Act, excludes completely from its coverage multiple groups of workers who constitute a central component of the U.S. labor force. So I think, as we'll hear more about later, the Act denies protection to a significant portion of workers in the contingent labor force, foreclosing, for example, nearly all unionization possibilities for temporary workers. Supervisors are also out, meaning that tens, if not hundreds of thousands of workers, from nurses to craftspeople to knowledge workers, have no federal labor law protection. And lastly, for all practical purposes, the federal law now excludes from its protection undocumented immigrant workers. But even for those workers who do come within the coverage of the federal law, the picture is not very bright. A primary issue is that the NLRA fails to prevent several particularly pointed forms of managerial intervention into the union organizing process, forms of intervention which create significant obstacles to employee choice. At the root of the problem are the NLRA election rules, that is, the way that unions are organized. So under current law, the only way that workers can obligate an employer to bargain collectively is by winning a board-conducted election. But the delay between the time that employees petition the board for such an election and the time that the ballots are actually cast creates a window of about 6 weeks. And the problem is that during this extended campaign period, the Act doesn't prohibit the use of a wide range of admittedly illegal anti-union tactics. So, as Harold says, in about 57% of the cases, the employer will threaten to close the firm if the union drive is successful. Somewhere again in the neighborhood of about 35% of employers fire union supporters during organizing campaigns. Okay, so this is the problem. To most of you, this will probably be very familiar. What I want to do is, in very cursory fashion, offer 3 potential alternatives for revitalizing labor law in the United States, and I'll close by suggesting a 4th. So the first is going to be a set of ideas for fixing the federal legal regime, ways to amend the statute or, much more likely, change the way that the law is administered to correct some of these flaws. The second and third responses are going to be ways in which workers and unions and employers can improve on the NLRA, not by fixing the statute, but by avoiding it. So the first possibility is to fix the organizing rules in order to better ensure that workers have a real choice on the union question. Here's what I'd like to suggest. Because the primary threat to employee choice comes from managerial intervention in the union organizing process, labor law can promote employee choice by minimizing managerial intervention. And labor law can accomplish this goal through a structural approach to the rules of organizing. In particular, by changing the election rules in a way that enables employees to conduct and complete their organizing drives without giving notice to management that a campaign is underway, the law can maximize protection for employee choice. So how do we design a new election rule? What would such a process look like? Well, assuming we can't do much in the way of statutory amendment at this point, what we have to do is design a system that includes a secret ballot election conducted by the National Labor Relations Board. That is, we need a system that preserves the secret ballot machinery while still giving employees a way of minimizing managerial intervention. So here are 2 possibilities. The first would borrow technologies that are already used in union elections in airline and railroad industries and let employees cast secret ballots in their home, over the phone, via the internet, or through the mail. As they do under current rules, unions would gather names of employees they believe work in the relevant unit. The board would then send these workers confidential voter identification numbers and tell them how to vote. If the union got more than 50% of the unit, it could demand recognition. The second proposal would borrow the model of early voting now used in U.S. political elections. Here, once the union reached a certain threshold of support, the board would set up a polling place which would remain open during the organizing campaigns. Employees could go and cast their votes in favor of or in opposition to the unionization. In neither proposal, and this is key, in neither proposal, would the board inform the employer of the existence of the organizing campaign before the voting was complete. That would allow employees to decide for themselves whether they want a union. After the voting ends, if the union won majority support, the employer would then be entitled to challenge the results. Now, here's the key. Because both of these proposals involve the NLRB in running a secret ballot election, both could likely be effectuated with either minor statutory change or potentially by the board alone. That is to say, the NLRB could itself make significant progress toward ensuring employee choice by altering the rules according to which union elections are conducted. Okay, so new election machinery is one approach to revitalizing labor law. Here are two other possibilities, which, as I said, depend not on trying to fix the federal law, but on avoiding it. The first involves the private reconstruction of organizing and bargaining rules by unions and employers. That is to say, through contractual agreement, unions and employers can build their own rules for union organizing campaigns and for collective bargaining. And in fact, across industries and geographies, unions and employers have been doing this for many years now. In some of these private agreements, the employer agrees to exempt itself from the organizing process, leaving the union question entirely up to the employees. Other agreements preserve the employer's ability to express anti-union sentiments, but tailor the conditions under which an employer may communicate those views in order to minimize the possibility for coercion. So a few statistics just to demonstrate how significant this trend is. In recent years, Unite and HERE, the garment and hotel workers unions, reported that 85% of their new members were organized through private agreements of this sort. SEIU organized far more private sector members through these agreements than under board elections, and relies on these in 100% of its campaigns in certain sectors. So by correcting some of the flaws in the NLRA regime, these private agreements not only offer better protection for employee choice, they can also give us some hints about how to reform the federal system, some data about how actually to approach labor law reform. Given these advantages, there is something that the NLRB rather needs to do today, and that is to facilitate rather than stifle the development of these agreements. Although the statute intends to favor private ordering of this kind, the board has issued a series of decisions in recent years that put up some roadblocks, and I'm hopeful that they'll change course on that in the days ahead. So the third and last avenue for revitalizing labor protections that I'll mention involves workers and their lawyers turning away from the National Labor Relations Act and relying on alternative statutory regimes, generally employment laws like the Fair Labor Standards Act or Title VII, as the legal guardians of their efforts to organize and act collectively. So here the idea is pretty straightforward. Employment laws don't offer explicit protection for union activity, of course, but these statutes do two things that make them a viable, if partial, substitute for traditional labor law. First, the statutes offer employees some substantive workplace right, minimum wage, for example. And second, they offer employees protection against retaliation when they invoke those substantive rights. So if workers organize around and fight collectively for the rights offered by employment laws, their efforts should be protected. And importantly, the protections offered by employment laws are more robust than those offered by labor law. To be sure, they're not perfect either, but whereas the remedies provided by labor law are weak and slow, employment laws offer punitive damages, and while the labor law vests exclusive enforcement authority in the board, which is plagued by endemic delays, employment laws give workers a private right of action. So a quick example of what I have in mind involves immigrant garment workers in Brooklyn and a collective campaign for better wages. So to demand overtime pay, what the employees did is they picketed their factory and they held demonstrations across New York City. The employer responded, as employers sometimes will, by firing the leader of the campaign, a sewing machine operator named Maria Arriaga. So rather than turning to labor law for relief, Arriaga and the Community Workers Center, where she was a member, pressed the U.S. Department of Labor to file suit under the Fair Labor Standards Act, under the minimum wage law. And with protests continuing at the factory, a federal judge acting pursuant to the Fair Labor Standards Act issued a preliminary injunction ordering Arriaga's reinstatement. That's something that almost certainly would not have happened under the NLRA. Arriaga's return to work in turn re-energized the campaign, and the collective efforts to secure overtime pay could successfully move to completion. So in very short form then, these are three potential avenues for revitalizing protection for labor rights: fixing the NLRA's organizing rules, relying on privately negotiated alternatives, and using alternative statutory regimes to substitute for traditional labor law. The fourth item that I usually talk about, which Maggie's going to do today, is state and local initiatives to improve or fill gaps left by the federal regime. I'll say something provocative, which maybe Maggie wouldn't say, and that is there is, it seems to me, a lot that states and cities can do now under the NLRA to make things better, but not a whole lot. And the reason that there's not a whole lot of room is because the National Labor Relations Act, as interpreted by the courts, has probably the most robust preemption regime of any federal law. And it seems to me increasingly clear that one way forward in the labor area is to relax or potentially eliminate the preemptive effect of federal labor law and to allow states and cities much more latitude in this area than they have now. I think this would be fun to talk about during the Q&A. There's no question that if we did this, some states would move in one direction and other states would move in the other direction. I think from a sort of a pragmatic standpoint, the question is, how much worse could it really get in Arkansas? And would that be countervailed by the rather dramatic improvements that I think we might see in other states?
Thank you, Ben. Anna.
Thank you. Good morning. So as Harold said earlier, I'm going to talk to you about immigration and immigrant workers. And when we originally conceived of this panel, I had these plans to tell you all about where we are with immigration reform and the protections afforded workers in the new bill and all of the new administrative and regulatory changes that have happened over the last year, which really are protecting immigrant workers. But I would be sitting here with a blank piece of paper because we really are nowhere with that. And so I'm not going to focus on that. And if you have any questions about that, I'm happy to answer later. So I'm going to look at the issue from a little different point of view, and I'm going to talk to you today about immigrant workers, but immigrant workers as the other workers, as workers left behind, as workers excluded from legal protections, either explicitly in law or in practice, or both in most instances. So I'm talking about workers specifically excluded from the NLRA, which Ben just mentioned, domestic workers, independent contractors, for example, as well as workers excluded in practice. Undocumented immigrants, they are too excluded in law, and low-wage workers more and more. These are low-wage workers, or workers who are part of a labor market that systemically is out of compliance with minimum standards, and one in which the relationship, the employment relationship envisioned by the NLRA just doesn't exist. It's a labor market where workers are contingent and often misclassified as independent contractors, which denies them with even more other basic protections. Now, not by coincidence, most of these workers, many of these workers are domestic workers, day laborers, taxi drivers, for example, are immigrants, and in large part undocumented immigrants. And by virtue of being undocumented, these workers are in a particularly precarious position. When that was facilitated by the Supreme Court in the Hoffman Plastic Compounds decision in 2003, which I'm sure you're all familiar with, which is a decision that essentially said that undocumented workers who are illegally fired for organizing under the National Labor Relations Act are not entitled to back pay. And that concept has been extended now to several state laws as well, and other Title VII and other laws. But I don't want to talk about Hoffman because I think that's been sort of a horse that's been beaten to death. But what the Hoffman decision did is it legalized inquiries into immigration status in the workplace. And at the same time, it gave employers cheap and easy way to bust a union by just that very question. Where are your papers? Show me your papers. That has both a chilling effect and a very practical effect, because employers are free to fire workers without any out-of-pocket costs when they're organizing a union. So yeah, the situation for immigrant workers sounds pretty glum. But what we're seeing with this worker population is that really what we've always seen, that no matter how hard employers oppress workers and suppress workers' rights to organize, workers eventually fight that, and they do, in fact, organize. And so these workers, domestic workers in New York, domestic workers in San Francisco and New Orleans, taxi drivers in New York, Philadelphia, Boston, Seattle, Los Angeles, and day laborers around the country are overcoming these legal barriers by, well, organizing, and they're organizing outside the law. They're organizing in worker centers, which are community-based nonprofit organizations that really function to provide workplace support, either in the form of legal services, community services, and more recently, workers are forming networks. Networks of day laborers, of domestic workers, again, and through these networks, workers, immigrant workers and undocumented workers are really making the old new again. And let me just give you an example. The AFL-CIO entered into a partnership agreement with the National Day Labor Organizing Network a few years ago, as well as we've done partnership agreements with other networks since then. And the reason that we did that is because we saw this growing parallel labor movement that was really the same. I mean, it was incredibly the same as we saw in the labor movement organized over 100 years ago. And we really saw the need to bring these two labor movements together, because we recognize that even if we get the Employee Free Choice Act done, if we pass labor law reform, if we implement a whole bunch of the legal reform that we absolutely have to do in this country, we're still not going to be able to grow the labor movement and to grow the power of workers until the labor movement itself is connected to community and until communities own the labor movement as their own. And so, in furtherance of this, we brought a bunch of union leaders to Los Angeles, Central Labor Council leaders and leaders from various unions to do a tour of day labor centers in Los Angeles. And we went to a place called the Gura Hills just out of Los Angeles, which is kind of in the north, and there was a lot of new construction at that time. And we got there about 5 o'clock in the morning, and the workers were huddled in this corner, talking about something, and the car would come by and stop and ask for a worker, and one worker had been instructed to go up to the car and say, "We're busy right now, you have to come back later." And cars would go away, and indeed they were busy, they were setting their own minimum wage, and the workers decided that they were going to not work for less than $15 an hour. And among themselves, they were negotiating the conditions. Well, what if somebody gives me lunch? What if they give me the tools? And they came up, they agreed on all those terms, and so then they decided that they would work for $15 an hour. We came back a couple of months later with a new set of labor leaders, and the same workers were still there, working out of the street corner, but a few of them had sort of walked down the hill. And a few of them had, were actually taking work, not under the $15 an hour rule, because they had sick kids at home, because they needed to send more money back home. And it was very interesting to see that the workers at the top of the hill, the organized workers, sort of went down and had a conversation and very sort of gentle persuasion of why the workers who really had all of these specific needs really needed to be part of the collective. And what's very interesting about this, if you look at the constitutions of the building trades unions, of the different crafts, you'll see that that's exactly how these workers organized more than a century ago. They set their own standards, and it's in their constitutions, and they enforce these same standards through collective action. And so really this movement, this worker-centered movement, is really the rebirth, in our view, of the labor movement, and it's a way to bring regulation into this world that workers just are living in the absence of a rule of law. I want to close now by talking just very quickly about a hybrid campaign that we're working with now, and really, which to us, it's a synthesis of, or a hybrid of this new sort of community view of organizing, and it's not so new, we recognize that, but it's a new experiment for us. And it's traditional NLRA organizing as well, and it's a campaign that we have in Los Angeles with car wash workers. There's about 10,000 car wash workers in the greater metropolitan, if you can call it that, Los Angeles area. There's more car washes in Southern California than there are in the rest of the country combined.
We pride ourselves on that.
Yes, and Angelinos love their cars and want to keep them very clean. Well, there are 10,000 workers in this industry just in Los Angeles, and they work in about 400 different car washes around the area. These are, basically remote locations where workers, there's, the biggest car wash has 12 to 20 workers, and they're mostly family-owned. There's the largest chain of car washes in Southern California has 4 car washes. This is an industry that is systemically out of compliance with minimum wage laws. Instead of making the $8 an hour minimum wage in California, car wash workers in Los Angeles usually work for 40 hours a day, and these are often 10-hour days, in horrible conditions. They're exposed to chemicals, heat, they have no water, and it's really, it's an entire industry that's operating below minimum standards. So, and then that's the reason that there are no car wash chains in Southern California. There are in the rest of the country. But legitimate employers find it very difficult to compete in this market that's completely out of compliance. These workers, car wash workers in Los Angeles, are mostly monolingual Spanish speakers, mostly undocumented, although there are some who have been in this industry for a very long time, and mostly male, although there are a lot of carwacheras who are actually organizing in their own way, and I'm happy to talk to you about that as well. So we have a campaign that the labor movement didn't start. It actually came from the community. And about 10 years ago, legal service lawyers in Los Angeles started to really see that their offices, they saw more and more car wash workers come in who just had their wages stolen or were working in very dangerous conditions. And they started doing what lawyers do best, filing wage claims, both in courts and administrative claims. And what they saw was that these cases were successful, but they settled often for pennies on the dollar. And the bad actors continued, and they often settled with confidentiality clauses. So the bad actors continued to act badly. There was just a cost, the price of doing business, which was worth it for this industry. The advocates also worked with the labor movement to pass a law, a car wash registration law. I mean, that's another standard tactic for legal organizing, is you pass a law requiring car washes to register, and that would bring regulation to this industry. Again, the law didn't have teeth. The governor signed it reluctantly, and then there was no regulations implemented under it, so that actually didn't work either. And so the community advocates and the car wash workers themselves recognized that in order to have a system where they themselves are able to enforce their own standards, they would eventually have to get to collective bargaining. Because short of that, they were always going to be fighting to preserve what they already the gains that they already made. And they recognize that it's the labor movement that actually brings institution and to preserve the gains that the workers had been making all the ground all along. So the steelworkers took on this campaign, and it's for us, it's a new model of community organizing, because the community, since it was their campaign to begin with, I should say now our campaign, is very much of those, both sets the strategy for this campaign and is very much involved in the day-to-day running of the campaign, along with the union organizing team. And it's been a fascinating experience for us because it's really a blend of cultures. We have the community organizers who are used to putting out fires, who have this mentality of just very much working to deal with what's happening today. And we have very structured union organizing, which is systemic. We rank workers are 1, 2, or 3. We like to have some organization. So it's been a very fun campaign and a very interesting way to sort of look at how different groups of workers have been organizing. Our vision for this campaign is that at the end of the day, there's going to be a steelworkers local that will function as a traditional local, enforcing collective bargaining rights, and servicing workers, and at the same time it's going to act as a worker center, so providing all the cultural services and the community-based services that worker centers provide to community. How are we going to get to collective bargaining is we've set up a model through what we call a clean car wash agreement, which is an agreement that employers have been asked to sign, which just brings the employers up to basic standards and allows for monitoring. It's based on the Nike sort of garment worker models of the past. And the idea is that once enough car wash owners in Los Angeles just agree to abide by minimum standards, there'll be enough density in the industry where the owners will come together and be able to bargain as an association. So I think that the challenge for progressive lawyers out there is to really develop the kind of legal structures, the legal protections for these different groups of workers who have been just organizing on their own, and that's not easy to do. You know, car wash workers aren't the only ones. Domestic workers, I have to say, are also doing fabulous work. And we just finished the first year of a 2-year process at the ILO in Geneva, where we actually got a draft instrument, which is an international convention that will set international labor standards for domestic workers. And domestic workers are very much themselves involved in this process. So I'll stop there. Thank you.
Thank you, Anna. Maggie.
Yes. I would like to first to thank the American Constitution Society for asking me to be a panelist today. It really is a pleasure to have a forum where people actually care about workers' rights to organize and to bargain collectively about their economic livelihood. And it really is a privilege to speak to people who care about that. As a preliminary matter, to answer Ben, I absolutely agree with him that we should be doing more in the states to foster the rights of workers to organize and bargain. I have a feeling that Willis may disagree about that, but I absolutely agree with Ben that that's where we should go. And that's what I'm here to talk about today. As Anna and Ben have said, federal labor law excludes several classes of workers from its protections. It excludes agricultural laborers, it excludes domestic service workers, of whom Anna was speaking, and it excludes independent contractors. But the economic reality is the fastest growing occupations in the U.S. are workers who work in those occupations. I am going to speak specifically about home care workers and child care workers, who are commonly referred to as independent providers. And the independent providers have, and this did not start right now, but the last decade there has been an explosion in organizing these providers and giving them the right to bargain. It first began, I would say the big organizing began in California in the late 80s and in the 90s. We have people, these in-home service providers, and in California, they're called in-home support service folks that take care of low-income, elderly, and disabled people. Currently, there are over 400,000 folks that are in that category and receive IHSS services, and there are over 300,000 providers in the state of California who deliver these services. When this, and it began, the money, public dollars, California had a program since the 70s, but then public dollars also came in with Medicaid, where there's Medicaid monies. And another reason that a big explosion too with the Olmstead case, where the Supreme Court said that institutionalizing folks is a violation of the ADA, the Americans with Disabilities Act, if people could, if they were able to stay within their homes. So the deinstitutionalization of these folks actually had a great increase in having people be in their homes with dignity and having their own care. So in California, the workers who wanted to have a voice, and in California it's operated each county. So the 58 counties in California run these programs. So there's federal money, state money, county money in these programs. And LA County, which is the largest county, these domestic workers wanted to organize, but no one would be the employer. There's no employing entity. So it was challenged in the courts, and in 1990, the California courts held that the county was not the employer, that the consumer, the client was, the disabled person, was actually the employer. That, and these people independently contract with these disabled and elderly folks. So a groundswell happened with the unions and disability rights groups and seniors groups and said, this is just wrong. I mean, that we need to have some structure that takes care of the quality of the program. We need to have standards. The workers need a voice in their job. So in 1993, the California legislature passed a statute that said that counties may set up a public authority, which would be the employer of record, where they could set up a bargaining structure, an organizing structure, and where they would actually have standards to improve the quality. 3 counties did that, the northern ones, San Francisco, San Mateo, and Alameda. Then the California legislature passed law, a better law from our perspective, in 1999 that said it was mandatory for all counties to set up this structure. So now the counties in California have this public authority where they have individuals, and it's a little different. Some counties have the Board of Supervisors, that is the employer, but they actually have a council that's made up of community and disability rights groups, and workers, the workers who deliver the service, who are on these boards. And the employer of record, the public authority, bargains with the union. And as Ben said, which is really important, the workers have a choice. The workers, the majority of the workers, elect to have the union. They say they want the union, and then the union represents these workers, and they bargain with the public authority. Now, in the last decade, there have been many states who have employed this structure. You need to have some legal vehicle to have an employer when you go to the bargaining table, and for workers to have a voice. Now, the concept of getting an employer is not a new one. Public employees are excluded from the federal labor law statute, from the NLRA. So traditionally, you had to get public labor law statutes. It began in Illinois with an executive order. You had a governor issue an executive order in the 70s, which then subsequent legislation was passed. In Maryland here, in the 1990s, we had Governor O'Malley issue an executive order, which subsequent legislation was passed, and now state workers have the right to organize. In California, agricultural workers excluded from labor law. California has a statute that allows agricultural workers to organize. And even before the NLRA included hospitals, private sector hospital workers, some states allowed those workers to organize because the NLRA did not. So this whole vehicle to get workers without a voice, to give them a structure where they can organize and bargain, has been developing. And several states, there's just an executive order in play. The state of Iowa has an executive order that allows child care workers and home care workers to organize if the majority of folks vote to have a union, and then the state sits down and negotiates. Some states had an executive order, which then moved on to legislation, such as the state of Wisconsin. They've done that. Some go straight to legislation without an executive order. But currently, there are 14 states that allow child care providers to organize and collectively bargain. Their representative can collectively bargain with the entity that is the employer. And in home care, there are 11 states that allow this to happen. So the organizing that's going on is really happening at the state level. And the statistics in the federal sector, under 8% of workers are unionized. In the public sector, almost 40% of workers are organized. Where some people say that the NLRA doesn't work, I could be in that category where I think it doesn't. Where the structure of the federal labor law is set up that it's economically better for an employer in a cost-benefit analysis to fight the union than to let the workers organize. As Ben alluded to, the remedies, why do people think that other laws are better? The National Labor Relations Act remedies are the worst of any labor statute. The remedies, post a notice and sin no more, and that's what they get. So I think that if, when there's no remedies, the people have no rights. And I could talk about all the structures that we have, but I can leave that later on, but we'll let Willis talk about the NLRA.
Thank you, Maggie, and now Willis.
Well, thank you, Harold, and I think this is the third time I've been on a panel at the American Constitution Society on this or a related issue. Always, of course, speaking from the dark side, and
we agree with that.
Always with roughly this ratio. But I do enjoy it. I can't figure out whether the Praveen and the others who organized this keep asking me to come back because they like what I have to say, or they're hoping to turn me around. Let me just give you the 30 or 40 seconds on my own background and my own experience, because I think it's going to be relevant to the things that I have to say and the things that I don't say. I've been a management and labor lawyer for close to 40 years. I've represented only management. I have had a practice that is largely one of representing very large employers, most of which are substantially organized, or at least many of which are substantially organized. I don't have any experience really with respect to the kinds of issues that Anna or Meg talked about, at least any practical experience. So I can't add much to what they have said. I do want to, as a result, focus a little bit more on the kinds of issues that Ben explicitly and Meg implicitly raised with respect to the National Labor Relations Act. I also want to make clear, and this is going to be something that I'll refer to indirectly in the course of my comments. I'm not Pollyanna here. I don't believe that all employers are always right, any more than I believe that all unions are always right. There are obviously, at the extremes on both sides, bad actors. And to get into the substance of what I'd like to say before Harold asks us some questions and we get questions from the audience, I think it really is unhelpful, especially at this point in our country's history, and given not only our economy but the global economy, to address these kinds of issues in an anecdotal way. And by anecdotes, I mean to point out the bad actors and say that those bad actors exemplify what the real problem is with the NLRA or what the real problem is with this or that. I think also the statistical arguments, while really interesting, are also anecdotal in my view. Look, I've read the Kate Brofenbetter studies, and for every one of her statistics gleaned from interviewing only union organizers, I can find you statistics from Union Facts about a whole parade of horribles and a whole set of other statistics that are completely to the contrary. So I don't think that's helpful either. What I'd like to start off by saying is, I think you should think about the premise, even the premise of this discussion that we're having. The premise is that it will always be in the interest of employees to have a union, and that if given sort of the unfettered, uninterfered with, not hearing from the other side perspective, employees will always choose a union. Well, that's simply not borne out by the facts. And by that I mean that either employees on their own, where employers treat employees fairly in terms of wages and benefits and other things, decide that they don't want a union, or the union organizers, which is certainly the case in terms of a lot of the public comments that have been made by organizing officials in various unions. The organizers just do a terrible job, just a really bad job. Now, when you look at the non-union sector, and everybody's fond of talking about how there are only 8% of private sector employers that are organized, take a look at Working Mother magazine, or take a look at Black Enterprise. If you look at those magazines, and those are two that I looked at in preparation for my comments today, of the 50 employers that are identified by a working mother as the very best places for executive women to work and for women to rise through the ranks as executives, 36 are completely non-union. That is not an accident. If you look at black enterprise, the number, and they have 4 or 5 criteria for determining what kinds of companies are open to minority concerns, open to minority hiring, have minorities, especially African Americans, on the boards of directors and in high-level positions. 26 of the 40 that they identify are non-union. If you look at the entire high-tech sector in California, I mean, Bill Gates is a wonderful man, and he's given gazillions of dollars away. There's not a unionized employee at Microsoft. That's not an accident either. And that's not a function of ideology. That's not a function of political point of view. That's a function of very hard and, in many ways, unshakable facts. The real question for employers, and again, I'm talking about sophisticated employers that treat their employees fairly, not always perhaps in the view of every employee every time, but in the main, the real issue is what can, in a global economy, a union do to add economic value to my enterprise, economic value to my enterprise. That's what drives employers. And that is rarely a question of wages, benefits, and the like, because at the higher level, let's say, of employers in this country, there really is an equalization. And maybe that's as a result of, and Ben said a lot of things that unions have accomplished and put it in the past tense. That's true. Maybe that's a result of what unions have accomplished in the past. But there really is a level playing field at the upper ends, or even from the middle to the upper ends of employers in this country in terms of wages and benefits. You know, I'll tell you what the biggest concern that employers of the sort that I deal with on a regular basis have about union organizing. It has nothing to do with wages and benefits. It has everything to do with arbitration. That's the problem that most employers are concerned about, because you have a system in arbitration where a person who knows nothing about the industry involved, maybe a very well-intentioned person, but knows nothing about the industry. There's no discovery, there are no rules, and there are no appeals. And you have a person who can make a decision that really has serious economic implications for a company. So that's what drives most of these, again, I keep talking about more sophisticated employers. And you can have a 20-person workforce and be a very sophisticated employer. That's what keeps employers fighting unions. Yeah, employers also fight unions by paying more, by providing better benefits, and the government, because of the very statutes that Ben has mentioned, the FLSA and Title VII and others, serves as, in effect, a proxy for unions in many cases. So there really isn't, I think, on a broad-scale basis, the kinds of problems with the statute that Ben's identified. Let me just speak to a couple of those. By the way, any statute that's been around for 75 years can stand a little bit of fine-tuning, okay? I got that part. So we can look at that. But there's fine-tuning, and then there's something that goes beyond that. Now, let me just identify a couple of things, and I'll start at the back. Preemption is really has been a hallmark of federal labor law, largely at the beginning as a result of the union movement. It was the union movement that pushed for preemption, because it was the union movement that wanted and got a statute that was federal in nature and federal in scope. What's happened is that over the 75 years that the NLRA has been in place, and over the course of probably 60 years or so or more of preemption decisions by the Supreme Court, the pendulum, in the view of some, has swung a little bit. So, and Ben identified exactly the problem that those of you who are in favor of doing away with preemption need to focus on. Look, I live in Manhattan. I'm sure that as far as preemption is concerned, the union movement generally, no problem with no federal preemption in Manhattan, okay? You know, New York County can take care of itself in terms of the needs of workers and everything else. Same in California. California, most people on the progressive center-left side of things would say California can deal with its own issues. Ben hit the nail on the head. You do away with federal preemption, you're going to get very different results in not just Arkansas, but in South Carolina and in a whole lot of other states and a whole lot of municipalities, where at the end of the day, the union movement will suffer badly, and where the employees who are turning to the union movement for help will suffer equally badly. As far as some of the other things, some of the more technical ways to amend the statute, I'll just say one or two things about the technology point, the electronic voting that Ben referred to, and this is, this is often done on both sides or on all sides of every issue, and that is you borrow from statutes those things that you think will help, and you don't want to talk about the other things in the statute. Now, it is true that under the Railway Labor Act, the NMB conducts elections by electronic voting and remote voting, and it's an entirely different statute set up for entirely different purposes. But if we want to pick and choose from the RLA certain things that employers who are subject to the NLRA might want, let's give each of us a shot. Let's give, for example, you want to have electronic voting? Let's, in big companies, have nationwide units. All right? That means that you would have to organize pick a company. The favorite whipping boy always, of course, being Walmart. You got to organize everybody, all 1.5 million. All right, that's the way generally it works. I'm not an RLA expert, but that's the way generally it works. There's a cooling off period. You can't have a strike. I believe under the NLRA, under the RLA, still without having a presidentially appointed board to sort of mediate the dispute. So you can't really pick and choose. The idea of having electronic voting in a unit of 10 people. Is kind of a staggering concept given the number of 8B charges, that's union coercion charges, and the fact that, I think need to make this clear, and this is the last thing I'll say before turning it back over to Harold, most union organizing drives in small units, and the overwhelming percentage of units in this country are small units, they are conducted before the employer knows anything about it. The reason often that union organizers make their presence known to employers is specifically to get the protections of the National Labor Relations Act. They want the employer to know I'm the organizer on the theory that I can't be discriminated against and so on. Now, does all of this work perfectly in all respects? No, of course it doesn't. But in a unit of, I would say, anywhere under 50 people, at least in my experience, the lawyer or whoever they're using to deal with the organizing drive gets the call after the petition's been filed. And the first question from the lawyer is, you didn't know that they were distributing cards, you didn't know that they were leafleting at the local convenience store at the mall. So most organizing drives are conducted quietly and in private. Organizing drives like the one that I was involved in the mid-'70s at the Newport News shipyard, where there were 18,000 people in the unit, no, that took 2.5 years, and the steelworkers did an absolutely spectacular job in organizing that facility. It's now the largest steelworker unit, local in the country. That kind of organizing is done in the open. So with that, I think I probably even exceeded my time, but we can turn it back to Harold.
Thank you all. I'm going to initiate a discussion here, reserving for my right for one purely journalistic question at the end. But I want to begin by asking Ben. Willis was talking about a kind of global trade-off in which if you shift to different voting methods in the for conducting NLRB elections, the quid for the quo is you've got to go to RLA rules which require national. I mean, the NLRB does not have to do that, does it? I mean, the NLRB is pretty much free to determine actually how the elections are conducted without, using the RLA as a template. Isn't that correct?
That's correct. So I think, let me respond to that actually by taking up something Willis said more broadly, and that is that he wants to challenge a premise that it's always in the interest of employees to choose a union. That is definitively not the premise of the Act. I agree with you.
No, absolutely not.
And it is definitively not the premise of any of my proposals. The premise of my proposals is that the statute ensures employees a free choice. That is to say, employees should be equally free to choose a union or not a union. The reality is that under current conditions, it is easier for employees to choose to remain non-union than it is for them to choose a union. It is tougher to choose a union than to remain non-union. And that asymmetry, right, means that we don't actually have genuine choice. What we want to do is we want to figure out a way of getting us to a place where workers are in fact equally able to choose union or non-union. So how do we do that? Well, one way we do that is we look around for other examples of things that work. Right? So one thing that seems to work or might work a little better is electronic and phone and internet voting as used in the RLA. Another thing that might work a little better is a model of early voting as used in our political elections. Right? The endeavor here is to figure out things that advance employee choice. The fact that we borrow a mechanism from the RLA that works seems to me to have nothing to do with other aspects of the RLA, like national bargaining units, which by and large would inhibit employee choice. So if the goal is not to put more people into unions, which is not the goal, if the goal is to advance employee choice, then we look for mechanisms that advance choice, and I think it's a totally reasonable and good strategy to pick and choose things that work.
Willis, this may be a wholly naive question, but were the NLRB in fact to adopt Ben's proposal and allow balloting by mail, balloting by computer, what have you, do you have a basis for a legal challenge?
Well, it's interesting how the NLRB has gone about doing that, because actually last week, or maybe the week before, and this is kind of the from my side, you would say, the stealth way of doing these things. Rather than amend the statute, what they've put out is an FAR, a requisition for a contractor to provide, I guess in response to a request for a proposal, ways in which electronic voting can be done. Look, I think there would be a legal challenge. I think that even if there, and to be honest, I haven't thought through all the possibilities, but I can tell you there will be a legal challenge.
That I assume.
That is absolutely 100% a guarantee.
What I said was, do you have a basis for a legal challenge? Not will there be a legal challenge?
There will be a basis. There will be a basis. No, I mean, I think, we talk about secret ballot elections. One of the real, and secrecy, in Ben's articles, he appropriately talks about secrecy, and I can come back to some of the comments that he made about asymmetry in this context. But look, one of the real problems again, don't think of nationwide units. Think of a unit of 30 people, okay, where the union has organized, or at least gotten 50% of the cards, or whatever it is that they've, under the regime that people are thinking about, gotten. They feel that they can organize the place. Think about the home visits that are allowed under the NLRA that are not allowed I believe, under the RLA. Then certainly employers are not allowed to make home visits. Think about the potential for intimidation and coercion. Absolutely not anything that the Act permits. And what are the subject of the overwhelming majority of the thousands of charges against unions filed every year. So, on the basis that you really can have an effective free choice if employees are going to vote by telephone or by computer with the person who organized them looking over their shoulder, even if they have a PIN number and even if they, have a way to access the voting mechanism privately. How are you going to know if anybody's there over the shoulder telling them to do it?
Harold, may I respond to this?
Sure, and then I have a question
Okay.
for you, Maggie, but yes, respond.
Okay. When we're talking about the NLRA, and I think the NLRA is a great statute for the 1960s. I think that Willis is
That was a
talking
very good
about-
era, by the way.
That's Willis is talking about a global economy, but we can't even use the internet to vote. We have NLRA practices that are for an economy that no longer exists. We have things for workers. We are treating workers as if they are working in a 1960 factory. They are not. We don't have industries here anymore. We have a few. The economy is different. The law is stagnant. The law as it currently is does not work. The reason that we want to go to the states, or I said I did, not because I think I'll get a better deal for the workers in New York, is because I know I get no deal with the federal law. When Willis said that employers can't go to the homes of workers, the employers have the workers for 8 hours a day. They don't need to go into their homes. And as a matter of fact, some states are passing worker freedom acts that say an employer cannot hold captive audience meetings to talk about religion, politics, or union organizing, because the employer is there every day. But I just want to say that the act to me is fine for a 1960s world.
Maggie, one question on you're talking about home care and child care workers. You enumerated some states where these have been won basically through, I guess, a gubernatorial executive order. I think you cited Iowa, where the governor is a Democrat, Chet Culver. Just reading polls, he may be unseated by Republican Terry Branstad. Presumably, therefore, a Republican, a governor who didn't like, never mind party, a governor who didn't support this could rescind or issue a new executive order, and what would happen then to the existing structure and all of those workers?
In most states, the executive order is only as good as the term of the executive, who is the governor. So you're absolutely right, and in some places where there's executive orders, they could be rescinded. In Willis's great state of New York, Governor Spitzer issued an executive order to cover child care workers, and Governor Patterson issued an executive order to continue that executive order. And just this week, the legislature has passed, the Senate has passed a bill for child care workers to organize and collectively bargain. But Harold is absolutely right. If you start with an executive order, it is only as good as that one executive. And that's why some states went directly to legislation instead of the executive order route. But of course, having an executive order, having a constituency of one as opposed to constituency of the entire legislature is sometimes an easier vehicle to get the organizing and the collective bargaining rights enacted.
I have a question which some of you, more than one of you, might be able to address. I want to direct it at Anna. First, it's about misclassification. It's about the whole issue of workers, and certainly there are a lot of immigrant workers, workers in the informal economy to who this applies, who essentially are working full-time regular jobs yet classified as temps. Are there administrative, executive branch remedies for this, or things you're leaning on the administration for on the misclassification issue, and does some of that have to be addressed statutorily, or what are the lines there?
I was going to actually talk about that, and also I wanted to, through the misclassification or the reclassification of workers as independent contractors, to address what Willis said about Microsoft as well. But yes, misclassification is a huge problem for immigrant workers. It's a huge problem, particularly in the construction industry, where workers are routinely misclassified. There are both administrative remedies that we're working on now with the Department of Labor about that, but there are the states have actually been doing a pretty good job, or actually trying to address the misclassification issue. And Illinois passed a very good misclassification law. I think that Kansas did as well, and it's a pervasive problem. Here's an example of how, even though when we have legislative reform on the misclassification issue, employers find a way to get around that. In Illinois, a very strong misclassification law was passed. In the construction industry, employers then started to encourage the very workers that they had misclassified the week before to set up an S corporation. And so they were able to do the very same things that they had been doing through misclassifying workers now by just actually creating actual independent contractors. So I think that that we really have to go back to to the structure of what employment relationships are now, and it's not just about the law. You know, Willis mentioned Microsoft. Yeah, he's right. It's not by accident that Microsoft is not organized. It's because Microsoft has used the new corporate model of creating independent contractors within its own corporation. That is very popular now, and that just by restructuring in that way through its corporate practices guarantees that there are no workers that actually can exercise rights under the NLRA. And in the low-wage worker sector, that's happened routinely. Look at taxi drivers. Taxi drivers used to be unionized around the country. Taxi drivers used to rent their cars. And then with the stroke of a pen, the industry changed. The industry changed, and now taxi drivers have to lease their cars. And instead of the way it used to be when they rented their cars and kept a portion of their earnings, now they lease their vehicles and they have to pay a flat rate. And that relationship, just the restructuring of the employment relationship, denied them the right to organize in states around the country. And that in and of itself busted unions around the country. So yes, the independent contractor issue is a huge problem. And it isn't just something that can be cured just by changing the law.
And if there's any sort of classic example of the kind of 22 cushion shot required to organize independent contractors, anyone who has followed the truck drivers at the LA Harbor, in which the organizing strategy involves an environmental regulation at the LA Harbor about truck emissions, which requires an upgrading of trucks, which requires, the hope was, creation of actual employers, getting rid of the fiction of independent contractors who could afford to upgrade the trucks. You can understand the complexities, difficulties, and everything else of organizing independent contractors. We are now at the point where we welcome questions from all of you. I believe someone's got a microphone, is that correct? Yes, right here. So wait for the microphone. Here's our first question, and if you could just identify yourself and tell us who you're asking.
Yeah, my name's Eddie Eichis, and I am president of a unit of AFGE, and the topic, of course, is the labor law and the right to organize. And I wanted to ask about the Obama administration and TSA, specifically TSA workers, why they can't organize, what law prevents it, and why the Obama administration has not done more. And if you want to talk about EFCA, you can also talk about EFCA.
Oh, I'll answer that. Look, I think what's really interesting about this, in all seriousness, is that if there were ever the possibility with a new administration for a wholesale revision by the stroke of a pen of a lot of the provisions that many of you in this room, I think, would like to see eliminated by the stroke of a pen, this was the administration. And so far, hardly anything. And I think that reflects actually the political reality. The lack of a political will here to do these kinds of things reflects the political reality of what is in effect a center-right country. And if you look, for example, at the with great fanfare in I think February of 2009, the administration, there were 3 executive orders, to go to Meg's point. One, economy and government contracting, right? Which I would say, well, I can tell you is going to be challenged. It's going to be challenged on preemption grounds. It's going to be challenged on various grounds. Now that the regulations have been proposed, it took a year, 1 year, to promulgate regulations, this is out of the Labor Department, that do nothing more than parrot a very short executive order. Now, the comment period ended last week. The regulations just repeat a year later. I think the regulations came on April. The proposed, do you remember? It's like it's over a year later. They just parrot back the verbiage. The comment period ended June 14th. There are going to be comments. The political will isn't there for pushing these kinds of things, and I think it reflects the reality of the country and the reality of the political situation.
So the way I'd respond, I think, slightly differently, and that is to say, the one question is, what does the defeat of EFCA teach us? And the second is, what do we do about it? And so going back to 1977, there have been multiple attempts to pass labor law reform. They've actually all had majority support in the Congress. And they've all died through the operation of things like the senatorial filibuster. So I think there's an interpretive question there. When you have 59 U.S. senators on board for something, and the great majority of the House of Representatives and a president ready to sign the bill, does that reflect a center-right country, or does that reflect a senatorial rule of process, which says you actually need a supermajority? So that's the sort of the interpretive question. I think the what do we do about it question, the more pragmatic question is, well, it does not look like we are going to have federal labor law reform. I think that's correct. And that, I think, means that if we are concerned about things like employee choice, we have to look other places. One possibility is administrative reform of the statute. A more radical possibility, as we've all talked about, is moving away from the federal government and to the state and local. But I think the question is important because I think that is very much where we are. I think Willis is probably right that this was the moment for comprehensive federal labor law reform, and we didn't get it. And so, you know, there's starting in '77 and multiple times between then and now, it's the same political economy, which is that either side has essentially enough political resources to block the proposals of the other, but not enough to actually get anything done. And so if we think change is needed, I think we need to look somewhere else besides the federal government.
But can I just...
The first part of my question was
About TSA.
40,000 TSA workers. Ms. Napolitano, who spoke yesterday, could immediately allow these people to organize, and it's not happening. I mean, there's no statutory prohibition on allowing TSA workers to have rights. And I'm wondering why, aside from the Senate issue, why the Obama administration has not allowed that to take place.
Well, probably Ms. Napolitano is in a better position to answer that than anyone here. Maggie, do you have any quick thoughts on this?
No, I was going to say, I certainly cannot speak for the Obama administration. I just.
Well, I really love to.
I just cannot. And I do think what Willis is about political will and bend. I mean, people in the country don't even know the TSA is trying to organize. The only thing the political will are the politicians. That I sincerely believe that the regular working folk have no clue that TSA can organize. And it's just the political agenda why that's not done, and I cannot answer why they haven't done that.
All right. Other questions? Let's see. We have a person on the aisle there. Here comes the mic.
Hi, my name is Jessica Ahrens with the Center for American Progress. One of the reasons I think that so many progressive agenda items were backlogged, of course, was because the political chips were all put in the healthcare reform basket. And my question is whether it's the view of people, I guess anyone on the panel, about whether health reform will make labor organizing easier or harder. Because on the one hand, one of the major benefits I think that most workers get through labor organizing is healthcare benefits, and now that might be taken off the table. On the other hand, as it hopefully will bring down employer costs, maybe it gives more flexibility to employers to offer different sets of benefits to workers.
This is the old AFL position: keep the state out of it, let the union deliver. Any thoughts on that?
Yeah, I don't think that it will make it harder for unions to organize. As I said, I think the majority of the organizing was happening in the public sector arena, and you cannot sustain a public sector vital workforce with good wages and benefits without a vibrant private sector that also affords private sector workers living wages and health care benefits. And the private sector workers have been on the decline with receiving health care and health care benefits. There are, as you know, between whatever number we want to use, millions of people without basic health care coverage. I mean, part of the domestic workers, which is such an awful thing, the domestic workers who are taking care of the disabled in their homes were without health insurance. And the main thing the unions did when they bargained, the main thing that these workers want is to have health insurance. The average salary of the home care workers is under $21,000 a year. So when Willis is talking about, executives and good companies for executives, the majority of workers are not executives. The majority of workers, 200,000 domestic workers that New York just passed a domestic workers' Bill of Rights. It didn't have organization. It just happened last week, wasn't it, Willis? wasn't it? Where the first in the
Well,
country.
here's I have a solution.
To give them
I-
2 holidays a year.
I have a
give
solution.
overtime.
I have a solution.
But these are where the workers are. The workers are not the executives in the companies. The majority of workers, home care workers, are in the top 10 job classifications in this country, and it's the fastest growing job occupation in America.
So if the public sector union employees in New York City and in New York State who get fully paid health insurance to an extraordinary degree and who have an unlimited number virtually of
agree with that,
vacations,
first of all,
maybe they
but
should
I'm
give
just
up
saying,
some
I'm
of that
not
and give it to the
agreeing
home health care workers, and
No,
everything would be fine.
I think maybe some of the companies may be able to give up some of their profits to do this, because the disparity, the inequality between the executives and the regular workers has increased, and I don't know how many-fold. Mr. Trumka always knows that how big it is. Since 1979, workers' wages and benefits have declined. They have not gotten better for the average worker, except for public sector and a few other places, because we are kind of at a race to the bottom for these workers instead of a race to the top. And unless we have a minimum standard, coming back to your health care, a minimum of health care for people and a minimum of wages and some retirement security, I don't see how that the country, for workers, that it will be a good place.
Can I just answer that too? The labor movement has been involved in the battle to fix the broken healthcare system for decades. And we long ago realized that we could not fix the healthcare system at the bargaining table, then that was actually hurting unions. And now, if you look around most countries in the world where unions are strong and where density is high, are countries that actually provide health care to people who live there. So I think that, again, moving toward a country where actually provides a very basic level of health care is actually good for unions, because the reason that workers need unions are not just about this benefit or that benefit or that benefit. It's really a structural need. It's that unions are the only institution that preserves whatever gains they may have. It's the institution that allows workers to bargain on an even level with this huge corporate power. So I think that in the long run, it is going to be good for unions. The test is going to come in the next few years when we're going to see what happens at the bargaining table, especially with healthcare.
All right. More questions? Can we have the gentleman here? Wait for the mic, Cruz.
I have a
And say who you are.
Cruz Reynoso from California.
Former California Supreme Court
Yes.
Justice Cruz Reynoso.
I have a son-in-law who's a Republican and works for the government, and he supports unions, not because of wages and all that, but because it protects the workers from arbitrary activity by the employer. And I confess that I see non-government workers going through that sort of problem. Then I've read, maybe this is wrong, but I read a survey that indicated that 65% of the workers in private industry said they would like to have a union, period. That is, but only, 8% have it. Is that, am I misreading what the studies show? I seem to remember that.
Anyone want to comment on that disparity?
And I wonder how much of that is for wages and so on, and how much of that is to be protected from arbitrary decisions by the employer.
I'd have to go back and look. So there, as with any statistic, there are different studies. There was a study done by an economist at Harvard who found that, and my memory is, 50% of workers wanted a traditional union. 60-some% wanted some form of collective representation in the workplace. We could quibble about the actual numbers, but as you point out, what's dramatic and what's important here is the great disparity between how many workers want some form of collective representation, even if it was a half, even if it was a third of what these economists found. There would be some great distance between that and the number of workers who actually actually have such a union. And so then the question is, why? And I think it's fair to say that the legal regime plays some role in that representation gap.
Well, if I may, just for a second, I mean, the other clear disparity is if there's a 40% unionization rate in the public sector and a 7-point-something unionization rate in the private sector, you either have to believe that public sector employees and private sector employees are entirely different species of human being, that a FedEx truck driver has nothing in common with a U.S. Postal Service truck driver, or employer opposition to unionization actually makes a difference. It's either human nature or employer opposition.
Well, that's not right. I mean, there are basic structural differences between the public sector and the private sector. There are different incentives in the public sector and the private sector. And as we know, since every state in the country is bankrupt, public sector, you don't have to make any money. It doesn't matter. You just tax people and you pay for benefits for life for people who, work 3.5 days a week. That's the difference.
Now,
Well, why wouldn't you sign up for that?
It would take me so many days to respond to that.
Well, no,
but I mean, we don't have the time.
no, that's the
Honestly.
you don't have you just pass a bill and you just pay. You don't have to make money.
Now, if people look at before, the private sector was much more unionized than the public sector. But as I said, the law itself, the NLRA, never changed. They had 30% of people organized in the private sector 30 years ago. But what happens in the public sector and the private sector, it all comes down to economic power and political power. Your son needed to have protection because it's employment at will in the private sector. You're right. Unless you are part of a protected class, the employer can say, I don't like your earring, you are fired. And it is as simple as that. You are right. So most workers do want to say in that arbitrary decision-making by employers. So it's not because only 7% of people want to be organized in the private sector, where conditions are worse, where you have no constitutional due process rights. It's because the structure as we have it, and there may be many reasons why, but you have to look at the statute itself as one of the primary reasons why the workers cannot be organized.
Okay, let's take a question right here.
Yeah, my name is Jonah. I was an organizer with SEIU for 6 years, and I just finished my first year at Berkeley Law School. But my question was, yesterday there was a panel about the Arizona law, and it didn't come up, but I was wondering if, I can't help but think that that could be an excuse that employers can use to campaign against the union, especially with campaigns like the Justice for Janitors, where public actions like going out in the streets, doing rallies is so, we need that in order to win. And I can just see a lot of employers, Brother Willis, this happens, where, an employer takes a worker aside and says, look, we have this new law. And, if you are out there in the street, going out on strike, going to rally, then, I don't know what's going to happen. And I can just see that happening. I was wondering if the labor movement was doing anything about that.
Well, yeah, of course. I mean, the Arizona law is terrible. It's awful, but it isn't anything new. I mean, in many ways, the Arizona law has been playing around the country for years because there's a section of the Immigration Nationality Act, Section 287G, that actually allows the federal government to give the states the power to do exactly what Arizona is doing now. In fact, the whole Arizona law is built on 287G agreements. So what we've seen already is, in Arizona itself, and I have a video of it, somebody doesn't believe me, so it's just not anecdotal.
The video can be an anecdote. I don't
I have lots of videos.
I got a lot of videos.
Statistically significant number of videos.
I missed that. You're going to have to repeat that. Anna.
So it's the Iron Workers campaign. They have a campaign that is actually, they have roving pickets around the state. And a sheriff stopped. There was a group of the picketers were in a car, and they were stopped by the sheriff and asked for their papers. And then right before he called ICE, they have all the workers sort of sitting on the side of the road. And the Iron Workers organizer, this guy named Brady, who's not an immigrant, is filming this whole thing. And he asked the sheriff, so you're stopping us. Are you just arresting these guys because we were picketing? And he said, yeah. I mean, that's the power. That's big deal. It happens all the time. That's what we're going to see a lot of that. You know, in the South, in North Carolina state law allows companies to actually have their own police forces. So now, 287G agreements, Arizona-type laws, you know, so you have the security at Smithfield Packing and other similar companies who already were, you know, the police force for that huge plant, now have the power to ask workers for their papers and put them in removal. It's an issue that is absolutely a workers' rights issue, and it's an issue that we can't, I mean, it has to stop.
All right, I believe that the time for this kind of questioning has now expired. What we have now is time for informal questioning, networking, schmoozing, following which there is the lunch with Newark Mayor Cory Booker. So we are to encourage you, but also, anyone have just one last phrase you're dying to say? Okay, no. All right, so thank our panel.